All right, Sunday Law students, welcome to this explainer. If you're prepping for CLOT 2027, you already know passage-based questions on fundamental rights are just loaded with traps. So we're doing a high-octane rapid review today. I'm going to hand you the exact legal concepts, the specific tests, and the landmark case laws you need to instantly spot those traps and cross out the wrong options. Let's get right into it.
Here is our battle plan for today. We're doing a rapid-fire breakdown of Articles 14, 15, 19, 21, 22, 25, and 26. We are cutting out all the fluff and focusing purely on the mechanics of the law.
Section 1, Article 14, Equality and Non-Arbitrariness.
Okay, notice how Article 14 actually pulls from two totally different legal traditions. On one side, you've got the British concept from A.V. Dicey, equality before law. That basically just means nobody is above the law. Simple enough, right? But the American concept, equal protection of laws, is really where the magic happens. See, Article 14 doesn't actually demand the exact same treatment for everybody. It dictates that equals get treated equally and unequals get treated differently. But the state has to justify it.
So, how exactly does the state justify treating people differently? Well, they use the classic twin test from the Ram Krishnadamya case. When you see a legal classification in a CLAT passage, you need to instantly run it through this test. Number one, is there an intelligible differentia? Basically, is there a real, understandable difference separating the groups? And number two, is there a rational nexus? Meaning, is that difference logically connected to whatever goal the law is trying to achieve? It absolutely has to pass both.
Now, even if a law survives that twin test, it is not totally out of the woods. You also have to check for the arbitrariness test. This was introduced in E.P. Royappa and then confirmed in Maneka Gandhi. It essentially says that capriciousness is the direct enemy of equality. So, if a law or executive action is just unfair, irrational, or manifestly arbitrary, boom, it gets struck down immediately.
Section 2, Article 15, Prohibition of Discrimination.
All right, you've got to watch out for a classic exam trick right here. 15.1 stops the state from discriminating, sure, but 15.2 goes a step further. It applies to accessing public places, like restaurants, even if they're privately managed, as long as they use state funds. And what about clauses 3 through 6? Well, those allow special provisions for women, children, SC/STs, and the EWS quota. Remember, these are not discriminatory. They are purely protective exceptions that allow the state to actually help disadvantaged groups.
Now here's a crucial case law card you need to commit to memory. In Anuj Garg, the court laid down that protective rules for women under 15.3 must be genuinely protective. If a law is just, paternalistic or reinforces old stereotypes, then it's unconstitutional, plain and simple.
Section 3, Article 19, Speech and Restrictions.
Okay, if you get a passage about a speech ban, you have to box it in immediately. A speech restriction is only valid if it fits exactly into one of the 8 specific grounds under Article 19.2. We're talking things like public order, security of the state, or defamation. If the government tries to ban speech for literally any other reason, no matter how sensible it might sound to you, it's automatically unconstitutional.
So how do courts actually test these restrictions? If the state restricts speech citing public order, you've got to apply the proximate nexus test from the S. Rangarajan case. The connection between the speech and the public disorder must be direct. Think of it like a literal spark in a powder keg. A remote or speculative possibility of disorder, that's just not a valid excuse to silence speech.
And if a law is overly broad, immediately flash back to Shreya Singhal. This is a massive landmark case that established the chilling effect doctrine. It struck down Section 66A of the IT Act because the language was so vague it actually froze innocent people from speaking out online. So if your passage features a vague online speech law, this is absolutely your go-to precedent.
Section 4, Articles 21 and 22, Life, Liberty, and Arrest.
Let's tackle the heart of the Fundamental Rights chapter. Article 21 says no person shall be deprived of life or personal liberty except according to procedure established by law. Look at how massively this evolved over time. We started with a really narrow view in A.K. Gopalan back in 1950. But then the 1978 Maneka Gandhi case changed everything. It required the procedure to be fair, just, and reasonable, which created the famous Golden Triangle. From there, the right totally exploded to include livelihood in Olga Tellis and, of course, privacy in the 2017 Puttaswamy case.
When it comes to Article 22, this table is your best friend to instantly contrast two completely different realities. On the left, ordinary arrest protections.
These require producing a person before a magistrate within 24 hours, with lawyer access, all guided by the strict DK Basu guidelines. But contrast that with preventive detention on the right. Here, someone is detained on mere suspicion. The state has a strict 3-month limit before an advisory board has to step in. And as we saw in the Recca case, this is an extraordinary power that must be construed extremely strictly.
Section 5, Articles 25 and 26, Religious Freedom. Listen up, because here is a massive exam trick. You need to look for the conceptual friction between the individual and the group. An individual's right to religion under Article 25 is subject to public order, morality, health, and other fundamental rights in Part 3, like equality. But a religious denomination's group right under Article 26 is not subject to those other Part 3 rights. This exact conflict is what courts constantly wrestle with, and you'll see it all the time in passage-based problems.
So, when these rights collide, or when the state tries to regulate a religious institution, what happens? Courts use the Essential Religious Practice Test. Founded in the Schur-Mutt case, this test basically distinguishes true, core religious matters, which are fully protected, from mere secular administration or optional social customs, which the state is completely allowed to regulate.
All this friction culminated in the huge Sabaramallah case in 2018. The court held that if a practice isn't deemed legally essential to the religion, an individual's right to equality and dignity under Article 25 will completely shatter a denominational group claim under Article 26. You really want to keep that hierarchy in mind when you're evaluating options on test day.
All right, your final strategy for the CLAT is simple. Focus strictly on these core tests. If you see a restriction, test it for arbitrary action, check those 8 grounds of speech, or apply the Essential Religious Practice Test to eliminate incorrect choices instantly. Now, go dominate that practice set. But as you read that very first passage, ask yourself, are you just reading the facts, or are you finally ready to spot those unconstitutional traps hiding between the lines?